Welcome to Dad Talk Today. The podcast for dads facing some of the toughest moments of their lives. We are here to walk with men through divorce, keep them connected to their kids, help them understand their rights, and work for change in family law courts. Moms, you are always welcome too. We are all about advocating for shared parenting and doing what is best for our kids. Here is your host, Eric Carroll.
Everybody, welcome to Dad Talk Today. We are live with Mr. Kevin Hickey. Kevin, what's going on, man?
Hey, how's it going?
Going all right. I see you get to have you a nice little vacation. You're feeling rested up?
I did. I'm, somewhat tanned and rested and ready to go.
There you go, man. So guys, if you got any questions, please write them into Kevin. I will make sure that he gets them, and we'll talk about them. Again, just to let you know, this is not to be taken as professional legal advice, even though you're talking to a professional, and it does not create a client-attorney relationship. Now that we get that out of the way, Kevin, what's some misconceptions? Let's find something to talk about while we're waiting for people to get us some questions in here. What's some things that you would like to tell some of these parents that are going through family law struggles?
There's 100 different things that I could tell you about. The biggest thing is, and we don't talk about this a lot. I think it's always good to have a support network around you, friends. If you're a spiritual person, you go to church, maybe your pastor or a group from church, family that you're close with and that you really can confide in and that you really trust. Keep those people around you as you go through this, because this is not as we say a lot, this is not a sprint, it's a marathon, and it's going to take you some time. And it's hard enough to go through, but it's really hard to go through by yourself. Try to have people around you that you can trust and lean on, because there's going to be times you're going to want to text, your ex and say something you shouldn't say, or go on social media or something like that. And you need other people you can talk with that can kind of help you through, keep you from making mistakes like that as you go through your case.
Where would be some good avenues you think somebody could start? I say it's a little hard sometimes when you're talking to family. I mean, family is one that you need to have there, and, they love you and they want to be there, but sometimes they get equally as invested as you do. Mm-hmm. And that can be a little bit of a hardship. And then some of these parental alienation groups, you got to be careful, because hurt people hurt other people. Where are some places that you would recommend for them to go and get some of that support and to get some of those resources?
Well, sometimes, especially as your podcast has shown, sometimes you can find other parents that are going through what you're going through, and you maybe can talk with them one-on-one. Come to a podcast like this one, or find a reputable support group. Other people that are going through it or have gone through it before, that's a good place to start. Sometimes your attorney, you can talk to your attorney. They've probably been practicing for years and years, and they may know groups that you can talk with.
Right. All right, guys. So get us some questions rolling in here. I got one in here for you so far, Kevin. It comes from Matt Leffler. He said, what's the legal definition and terms for parental alienation?
As far as the legal definition, I don't know that there's really a legal definition, but a bunch of different behaviors fall under parental alienation, and a lot of states don't even use the phrase parental alienation. Anything that's designed or is having the effect of cutting one of the parents out of the other person's, out of the child's life, that's probably going to fall under parental alienation. So it's more of behaviors that are being exhibited. Sometimes it can be a psychological thing going on with the other person. You just never know. So you have to really look at the behaviors more than what the actual legal definition is.
I don't know about for you, but for some of the experts, it seems like nobody has the same definition of parental alienation. For any of our viewers that maybe this is their first time watching and they've never heard the term, what would you say is parental alienation, Kevin?
It's like I say, when one parent is engaging in a course of behavior or conduct that is causing the child to start to have a divide or a wall with the other parent. The other parent is basically being pushed out of the child's life. And there are 100 different reasons why that could be going on. This parent could, the alienating parent could have a psychological problem of some kind or mental health issue that is causing them to act that way. Sometimes they're perfectly fine with their mental health, but they're doing it out of spite or some other reason. They're mad at the other parent. They're trying to get a leg up during litigation. There are a lot of different reasons as to why it can be going on, but every case is different. And all I can say is if you start to see the other parent engaging in that kind of behavior, if your case is still going on, you need to let your attorney know, because alienation is something that you want to try to address as soon as you possibly can, because the earlier you can get involved in that, the better. And the longer you wait, sometimes you're really, really behind the eight ball by the time you go to court.
Gotcha. Thank you for that. Matt Gordo G-Ball said, what will happen if I'm behind on child support and now have to go to court again? Do I get a lawyer?
Talking about going to court again, I think maybe you're saying you've gotten behind on child support and maybe child support enforcement or someone has filed saying that you're behind. You don't have to get a lawyer. I always recommend that you do, because especially if you're dealing with child support enforcement, they are going to have their own attorney there. So you don't want to go in what we call pro se on your own when there's another attorney on the other side. At a minimum, consult with an attorney about it, because many times during a consultation, we can figure out what someone's child support is supposed to be. And if it's an attorney that handles a lot of child support issues, I handle a lot of child support issues. I can pick up the phone and call child support enforcement, talk to their attorney, and they can usually pull that case up and we can get it figured out. A lot of times, not all the time, but a lot of times we can get it worked out over the phone as to what you should be paying. And if you have an arrearage, like you're talking about here, that can avoid you having to go to jail or paying some kind of attorney's fees or fines or something like that.
Gotcha. Hey, appreciate that, Gordo. We got one from Mr. AJ Brout. He said, I have a follow-up hearing tomorrow to a temporary emergency hearing. Someone once again reported anonymous false allegations. I haven't any representation, nor does mom. The allegations are unfounded. What could I possibly say to see this type of thing cease? I don't really know what to expect besides getting my visitation restored.
Well, as far as getting it to cease, I mean, I know you want it to stop. You got to try to figure out the source of it, where it's coming from. The anonymous reports, that's fairly common. A lot of times you can never get to the bottom of who reported, called the hotline or whatever it's called in your state. You've got to try to find where it's coming from. Many times it's coming from the other parent or a family member of the other parent. Grandparents sometimes are the ones that are getting involved. You just never really know. As far as your hearing tomorrow, you're both going in there without attorneys. My guess is the judge is going to require whoever made this allegation to show some kind of proof. So make them prove what they're saying that you did. That's the burden's on them to do that.
Got it. Hey, appreciate it. AJ, we got one from Mr. Alan Escurito. He said, hi, Kevin. Last time I asked about remedies to perjury, hiding substantial income in child support, and I had to clarify that I found the fraud after the hearing. What do judges do when they see these things after the fact?
Well, a lot of times they don't see it unless you bring it up. You can file a motion to have the child support amended. If it's a substantial enough difference, or there was enough income that was hidden the first time around, you may need to file another motion to modify. If you had an attorney, I would either get the attorney on the phone or set up a time to go talk to them and tell them what you found or what you think the substantial income is that's hidden, and see if they think it's worth filing a motion to modify. A lot of judges don't like to reopen a case immediately after they just closed it. So, but every judge is different. So talk to the attorney that you used and see what they have to say about it.
Got it. I got another one in here from Matt. He said, so my ex and I have never been to court. I live in Utah and it is a pro-mom state. I'm looking for a lawyer. I have never been charged or had anything filed against me. Will I stand a chance to get my rights in Utah? Do you know about Utah and the pro-right mom state we have here in Utah? And I know that you practice out of Arkansas, Kevin, but I don't know, what you could say to Matt here.
I handled cases all across the country. I have not had one in Utah. Let's see. It says your ex and you have never been to court. So I'm guessing you were never married. If that's the case, a lot of times most states say that the mother has custody immediately if the parents are not married, and the father has to file some kind of an action. It's usually called a paternity action to get any legal rights. So that may be what you need to file. As far as getting your rights, yes, you're going to get your rights to be declared legally the father. Now, as far as what custody will look like and what kind of time you will get with the child, that's a whole different story. But you need to talk to an attorney, you need to file, and you need to get your legal rights established as a father.
All right. I hope that helps you out there, Matt. Mr. Eric Ritt Smith said, if an attorney was present at a hearing and the judge addressed the issue at hand, can the other party immediately file to relitigate the same issues that were already addressed?
Okay, let me read this real quick. If the attorney was present at the hearing and the judge addressed the issues at hand. Okay, so I'm assuming they're saying they want to refile right after the judge has already decided whatever was just put in front of him or her. Normally, you can't do that. There's a legal phrase. It's actually an old Latin phrase called res judicata. That's R-E-S. It's 2 words. Second word is Judicata. If you want to Google that and kind of look it up, and basically it talks about the law of the case. And what that is once a judge has heard a bunch of evidence and made a decision, usually you can't go back and have those issues relitigated. Judges don't want to rehash something that they've already been through. So some parties have to go back to court over and over unfortunately, over the years. They usually only go back to the last time you were in court, the last order that was entered. So any evidence from that order forward is what the judge will usually look at. So normally if a judge has heard the issues, made an order on those issues and that evidence that was presented, they will not go back and relitigate that. In fact, that's often an objection that I make and other attorneys make. If I feel like the other attorney's trying to go back, we call it going back behind the order. They try to go back with that old evidence and those old issues. I usually object and say, Judge, you've already heard that, and that's water under the bridge at this point.
Got it. Hey, appreciate it. Eric Winford on YouTube said, if CPS confirms an investigation was unfounded, could there still be an investigation with the prosecutor's office for the same accusation?
Yes, and this is really important. If you ever get allegations brought against you of some kind of child abuse, someone calls in on the hotline and makes a child abuse allegation against someone, 3 different things at least can be triggered by that. One is an investigation by CPS, or in Arkansas, we call it the CACD. They are part of the Arkansas State Police. They will investigate and determine if the allegations are true or what we call unsubstantiated. That is part of putting you on what's called the child maltreatment list. That is a whole separate procedure, whole separate set of rules and laws than criminal laws. The prosecutor can look at the same thing, the same allegations, the same incident that happened, and decide that a crime's been committed. And so, yes, they could do their own investigation and decide for the same accusation and decide that you need to be charged criminally. So you could have a maltreatment proceeding going forward. You could have a criminal case proceeding and going forward. And then something can be filed in your family law case to curb your visitation or custody, because all out of the same allegation. So you could possibly have 3 different things going on. Sometimes you can have just one of the 3. You just never really know. And I usually tell clients, be wary of anything you get in the mail, any police officer that calls to talk to you about this, because it gets very, very confusing for clients because they could have potentially 3 different things going on.
Got it. Michael Gilligan said, does the signatures on a marriage license give the courts personal jurisdiction over divorce matters?
My answer to that would be no. You do not, and we get this question sometimes, you do not have to get divorced in the same county where you got married. If you are validly married pretty much anywhere in the United States, most states will recognize that marriage license. Most states, you have to check on your state, and you can get divorced in the state. Usually you file for divorce where you're living, where you're a resident. So as far as the signatures on the marriage license, that's not what really gives the personal jurisdiction over the divorce. It's usually where you reside.
All right. Appreciate that, Michael. We got a pretty interesting question in here, Kevin, from this person. I don't think me and you've got to talk about this before, so I'm interested to hear it. Merge Music and Film said, Dad, talk today. Hi, gents. Kevin, what do you think of the Duluth model? Is it still used in the U.S., or have the courts finally agreed that it is a faulty model inspired by the feminist lobby? Kevin, are you familiar with the Duluth model?
No, you're going to have to educate me on that.
All right, so it was I can't remember the exact date. I think it's over 50 years old. It was made in, I think, Duluth, Minnesota. It's called the Duluth model, the power and control wheel, that basically says like 90% of the time the father is going to be an abuser. He's going to use man privilege against the woman, and basically is where a lot of the bias against men when they walk into family court came from. A lot of family law attorneys and judges are taught this inside of family law school. Some of them not, but it's still a very widely used model. I didn't know if you was familiar with it or not.
So this is a way they're trying to say for what are really abusive fathers getting away with abuse, or trying to get away with it. Is that what I'm hearing? Or
yeah, it's I'll have to get a model of it up. They've got it. If you look it up, the Duluth model, it's this little power and control graph, and it shows you all these different ways that the fathers use their privilege and are abusive to women, and it's very, very, very outdated. But
I guess what I'd say is I don't think much of it from what I've heard about it. As far as if it's still used, I've never heard of it, and I've never had a judge pull it out and say, okay, here's what I'm going to go through this model and look. I've just never seen it used.
That's good. I'm glad you haven't.
Have you heard of judges using that, Eric?
Yeah. Judges have been trained with it, and so have the family law attorneys. Melissa's the one that she kind of brung it up, to me and showed me, and I know she was taught it inside of school. It's not completely like used everywhere, but it's still pretty prevalent in a lot of the family law teachings. So
never heard of it.
Yep. All right. Hey, appreciate that, Merge. Michael Gillian said, is the collection of child support with CSEU voluntary?
I'm guessing that's child support enforcement for where he is. Is it voluntary? I think I know what you're asking. The parent that's supposed to be getting child support, can they voluntarily go and talk to child support enforcement about opening a case? And the answer is yes. They have the option to do that. Now, it can be involuntary, and child support enforcement will get triggered to get in a case sometimes if the payee parent, the custodial parent, the one that's getting child support, files for some kind of state benefits. They get WIC or some kind of anything that would be a state benefit, Medicaid, foods, what we used to call food stamps, things like that. If they're getting some kind of welfare or benefits from the state, a lot of times the state will look to see, is this a single mom or a single dad? Is there a parent out there that's supposed to be paying child support or should be paying child support? And then they will contact child support enforcement, and that will open a case on its own. So I think that would be more of an involuntary way of it happening, but it can happen that way.
Yeah. Stephanie Cochran said, what if the mom has falsely accused dad of threatening and been thrown out of court, all while an ongoing case is going on? Dad hasn't seen the kids since January 1st, 2020. Every time he's supposed to Zoom or see the kids, the mom makes up stuff. Why they can't, even though court has said it's supposed to start seeing them again. This has been ongoing, and he hasn't seen the kids over a year now.
So mom has falsely accused dad of threatening things, and I'm guessing that means the allegations were thrown out of court. You've got to do something. You got to have your attorney file something with the court to show mom's behavior. Not seeing the kids in over a year, that's way too long. That's gone on for too long. And if she has shown a pattern throughout that entire year of keeping you away from the children, and you're supposed to be having visitation, then something needs to be done about it. She's just going to continue to do it until you file something. Usually when we get hired on cases like this, I will talk to the client and say, do you want me to send her a letter first on our letterhead and see if that solves the problem? Or do you want us to just go ahead and file? And I just kind of leave it up to the client. And sometimes a letter solves it, but a lot of times we just have to file some kind of contempt. Judges, never forget, judges want their orders followed. They spend all day, every day, issuing orders, telling people what to do. And they try to make them, the judges I deal with, the majority of them, put together really good orders that tell the parties what they're supposed to do. And they want that order to be effective so that you guys don't have to come back to court. That's what I think people think judges want people constantly coming back to their court. They don't. They want to put something together that is going to work for you for years to come, for you and your children, for the parents and the children. And so if one parent is totally going against what they've ordered and what they specifically put in that order, and you have to bring them back to court, they're usually not very happy about it. So if one parent's not following it, you just have to go back to the judge and say, look, she's not following it and we need something done about it.
Hey, thank you for that, Stephanie. This is kind of an interesting question. Oscar Perez said, Kevin, why is man so unkind to mankind?
So we're getting philosophical, huh? I don't know. What do you think, Eric? Why are men so unkind to mankind?
I guess it would be I'd be curious of what angle he's trying to go at. I can tell you, and when it comes to family court, men are probably more critical of other men than I've ever seen, which you would think it would be the other way around, but they are. And I think the world has been accustomed to looking for the bad in people rather than finding the good. And social media has definitely not made that any better, I wouldn't say.
I agree with that.
Everybody speaks to talk and to speak, not necessarily to listen. And we've got to stop that. You know, we all live on this world together. All of our children, grandchildren are going to be in here. So we need to cut that crap out.
I agree. Hang in there, Oscar.
Yeah. Thank you for that. All right. Joseph Anthony Amaraso said, my ex has been disregarding court orders for over a year now, and the judge refuses to do anything about it. She has cited religious disagreement as a reason for alienation, and I am now in a mixed marriage. Any advice? It's been 3 years now, and she won't allow even a phone call. Claims my son doesn't want to, and the judge allows it each and every hearing and has not even told her boo about it. During her contempt of court hearing, the judge decided to reprimand me for a lie. And she said in court about, and it got cut off there. It got a little bit too long. Do you think you can get the question out of that, Kevin?
Yeah, I get the gist of it. And I don't know how to answer that. The judge needs to be doing something about it. If this has been going on for this long, you've just got to keep filing. And sometimes I have started numbering motions for contempt. So, because judges, you've got to remember, have tons and tons of cases. And every client I have thinks the judge remembers them from the last time they were in court. And most of the time the judges don't, because they just have so many cases and they just do. They're inundated with them. So you've really got to really point out to the judge what's going on. And a lot of times I will start numbering judges. Numbering motions. I'll put a second motion for contempt, third motion for contempt, fourth motion for contempt. So when the judge sees that come across their desk and it's being reopened, they see that number on there and think, wait a minute, this is the fourth contempt. What's going on here? And then maybe they'll start to read back through the file and see what's going on. But, those orders, Joseph, are appealable. So if you feel like you put and your attorney, you feel like you put everything out there the judge just missed it or got it wrong, you can appeal that. So you may have to do something like that.
Hey, hang in there, Joseph, and thank you for being here tonight, my man. Nathaniel McKnight Jr. said, if mother was ordered to pay for health insurance, will she be held in contempt? I have been health insurance for 9 years. I guess he's been paying.
So it sounds like she was ordered to pay it and you've been paying it. I think, Nathaniel, it depend on how that got started. If the two of you talked about it, or if you just started doing it and she let you do it. I think if you filed something right now, I don't know what a judge would do with that. If I'm the judge looking at this, I'm wondering why this has gone on for 9 years and hasn't really been addressed. So if that's an arrangement the two of you have had and now you want it to go back to what it's supposed to be, which is her providing it, you may want to let her know, look, you need to start doing this. And if you've already done that, or you know she's not going to do it, then you just need to file something with the court saying that she needs to take it over immediately. I don't know if it'll really be contempt. If you've been telling her over and over for years that she needs to provide it and she's not, then that may be a contempt issue.
I appreciate it, Nathaniel. Nikki Ward said, our judge ordered child to be in trauma therapy. The place she was at said they couldn't help her and they referred her to a new therapist. The mother refuses to let her go. How do you think the judge will handle that?
Well, that's another thing where a judge will come in and they make orders for a reason, and they really pay attention to the orders they make regarding children. Children's health, physical and mental, is crucial in a family law case, and the judge is always going to consider that and have that at the top of the priority list when she or he is making a decision. What is in the best interest of this child? So I'm assuming when this order was entered, this trauma therapy was very top of mind for this judge, and the judge said, we've got to have some trauma therapy and it's got to take place. So if mom does not have a good reason for refusing to let the child go, the judge is not going to be very happy about that.
All right. Loane Russian, I got to meet this lady up in Detroit. Such a sweetheart. Her son's going through a little bit of a battle, Kevin. She said, my son has sole legal and sole physical custody with the parents having to follow the county FOC guidelines. Will the judge keep the custody case in that county if he wants to move to a different county?
Yes. Well, every state is different how they handle that. A lot of times we have that happen here in Arkansas where one parent will move to another county. And it just depends. If one parent is still living in the original county where the case was brought, a lot of times they'll leave the case there. If both parents have now moved out of the county and neither one of them live there anymore or the child, then usually you can file what's called a motion to transfer it to a more appropriate county.
Gotcha. Hey, good to see you, Loanne. So I'm going to tell you a little backstory before I get to this next person's question. Her husband was very close to another John Mast.
Oh, okay.
Yep. It was last week we had her husband on, and his ex hired a hitman to kill him, and she's pled guilty to it, and she ended up paying an
on your show.
Yeah, she was on the show. She's got a question for you. So I mean, these are the kind of cases, man. It really, makes the hair on the back of your neck stand up because it shows you just how serious this stuff can get.
Absolutely. Well, yeah, yeah, and it seems worse than ever.
Yep.
I hate to say that, but it does.
Yep. So from Melinda Gore, she said, what options does a person have when a DA in a criminal case refuses to go to trial and settles for a substantially lower plea? The reason the DA is given is due to false allegations of sexual abuse that have been investigated by 2 county CPS agencies and law enforcement and have been determined unfounded. Yes, the ex before she done all this was making all sorts of false allegations against them, so they're not taking, even though she's pled guilty and everything, as serious. So
you've got, like we were talking about earlier, you've got 2 different agencies involved. You've got a prosecutor that's trying to make a decision on a criminal case. They have a beyond a reasonable doubt burden, which is the highest burden we have in the law. And it's a very difficult hurdle to get over in a criminal case. Then you have the CPS agencies, which are investigating, doing their own investigation, and whether they find it as true or unfounded or unsubstantiated, usually they have a much lower level. It's usually preponderance of the evidence, which just means usually just above 50-50 is enough to meet the beyond preponderance of the evidence standard. So one thing you're battling there is two entirely different standards. You've got a DA looking at it from the criminal law standpoint, and then you got CPS looking at it from the we just got to meet preponderance of the evidence or we don't. So many times when a DA sees, and I don't know what's going on in this case, but many times if a DA sees that CPS found it unfounded, they know they have a much lower burden. That does tend to cool them off on really going after somebody criminally, because the thought is, if the evidence didn't even meet the preponderance of the evidence standard, how in the world am I going to meet this super high hurdle of beyond a reasonable doubt? So that may be what's going on. And a lot of times, the next step after a prosecutor or DA makes that decision that they don't know that they can really meet their burden of proof is what you're talking about here. They end up offering a lower plea to try to get something. They want this person punished somehow. They don't want them to get off scot-free. And so that's probably what resulted in the lower plea.
Gotcha. Hang in there, Melinda. Until Derek, I said, hey, our next question is from Mr. Matthew Wells. He said, what are some things to say to mother/opposing counsel that has agreed to 50-50, but refuses to work with dad's non-standard firefighter, police, airline work schedule?
Well, we have that come up sometimes. And when we have a client that has an odd work schedule, we try to work that into the agreement so that they, again, like we talked about earlier, you're not having to come back to court and hash that out a year, 6 months, a year later. If you've agreed to 50-50 time, both parties, both parents are supposed to be working together to make sure that happens. And one of the biggest things you're having to work around is the work schedule. So if that's the spirit of the agreement and what was ordered by the court is 50-50 time, she needs to be working around that work schedule. And if she's not, you may have to go back to court to have something done about it.
All right, Matthew. Crystal Langhorn said, what do you do if they won't follow the divorce decree? He won't close the joint account. He won't pay through the clearinghouse, and he didn't pay for the car on time. He was supposed to, so it hit my credit.
Let's see. Joint account, he won't pay through the clearinghouse, and he didn't pay for the car. Take him back to court. Usually, again, we send them a letter or we file a motion for contempt and take them back to court. The decree is there. It sounds like it's very specific on what is supposed to be done, and if it's not being done, that's your option.
All right. Thank you, Crystal. We got a question in here from another attorney that I met out of Michigan a couple weeks ago, Miss Jennifer Payne. She said, question, what advice do you give to dads when they feel like they're getting poor treatment by the court? Any pep talk tips?
Poor treatment by the court. I think it depends on what's happening. If you feel like the judge is really biased, I don't know what you can really do to try to change that. It's very hard to file a recusal to get the judge removed and another judge appointed. As far as poor treatment, I guess I need a little more clarification on that. I try to tell clients when we're going to court that all you can do is really be yourself. And if you try to get them to act a different way, I learned after the first year of practicing, hey, do this or do that. You're probably asking for trouble, because every person is their own person. And if they try to start acting in a non-genuine way, it really comes across poorly. So don't know. I don't know really what else to say on that one.
Gotcha. Mr. Jeremy Culpepper said, can incident reports concerning parent withholding children be converted to an offensive report? Just found out about the difference yesterday. I
think what he's talking about is police. locally here in Arkansas, a lot of the local police I deal with, I'll see police reports, and they will put in there, this is an incident report. Parent didn't want to file charges. They just wanted this noted for the record or something along those lines, wanted us to make a report about it. And that may be what you're kind of talking about. Making it an offensive report, I'm not really sure what that would mean. I would think it would mean maybe you're wanting to take it to the next level and you've decided you do want to file charges against this person. So yes, I think you could do that. You could initially say, I just want this as an incident report, just to note what happened. I came here for visitation. She didn't show up with the children. I want a record of it. And then later, if you wanted to do something with it, I don't see why you couldn't take that to the prosecutor and tell them you do want charges filed on it.
Got it. Thank you for that, Jeremy. Adam Michael Hamilton said, why should one man or woman, a judge, a complete stranger, knows absolutely nothing but what he's been given by attorneys, spend a few hours at best to decide the fate of you and your children? That is wrong.
There was a judge that used to be on the bench here in Arkansas. I respected him greatly. I thought he was an excellent judge. And he would have two parents in there that were going at it. And then he'd start giving his ruling at the end and see them still going at it, griping, whatever. And he would finally say, hey, you need to listen to me for a minute. And he says, you two people decided at some point that you liked each other enough to have this child or children. And you've decided that you don't want to be together anymore for whatever reason. And he'll say, I'm not going to fault you for that. That's your decision to make. But the problem is you can't decide together how you want to handle this. So you're leaving it to me. So the best I can do is to listen to both sides, listen to the evidence that's presented, and then make a decision on what's going to happen and how this is going to go going forward. Now, Adam, I'm not saying that's your specific situation, but people sometimes cannot even agree that the sky is blue. And if we don't have a judicial system, we don't have someone that makes a final decision. If you're talking about a divorce, there was a piece of paper that you signed back at the very beginning when you first got married. And if you look at it, it'll probably say on there somewhere that you are licensed under the laws of the state of whatever state it is. Well, the only body that can undo that is something that is established under the laws of that state, which is a court. So you have to go to court to have them divorce you. And part of that is following the laws of letting that court decide custody and visitation and all those other things that you got to deal with. It's not a perfect system, but it's the system we've got.
Mick Barnett said, I filed for emergency custody last August because baby's mom is prostituting and judge sent us back to mediation. My lawyer does not contact me often, and we still do not have a mediation date. Is there anything I can do to get the ball rolling? And should I be concerned about lack of response from my attorney? I hear this one a good bit.
Go see your attorney. Call the office, set up an appointment, and go sit down with them. Attorneys are incredibly busy. If you look at the top reasons that clients are dissatisfied with attorneys every year, I stopped looking at the research. And I'll tell you why I stopped looking years ago. Because the top 2 or 3 are always the same. My attorney never calls me back. I don't know what's going on as far as our strategy. I can't ever get my attorney on the phone, or I can't get him to respond to an email. They're the same over and over and over again. We strive as best we can to be very, very good with communication. I tell the staff in the office, the easiest thing we can do is return a phone call. But even with that, still things sometimes slip through. We have 2 or 3 hearings, 2 or 3 days in a row that are occupying all of our time. It just happens. But I'll be the first to say that our profession is notorious for not being very good with communication. I tell you what most attorneys look at every day, if not more than once a day, and that's their calendar. So if you can get set up for an appointment with your attorney, just say, I need 30 minutes. write down the questions you have, and go in there and sit down with them for 30 minutes and ask whatever you want. That attorney works for you, not the other way around. So if you've got questions, ask them. And if you feel like you're not being contacted, tell them, but bring it to their attention. There's nothing wrong with doing that.
I'm going to play devil's advocate with that a little bit, because sometimes we don't know what all they are doing. I get some flack from time to time here from not being able to answer the questions, just from we're getting inundated with messages, man. There's so many people that are reaching out. And then one thing, I don't know if you could speak on this, Kevin, a lot of them are trying to treat their attorneys like a counselor. And that's probably one of the last things that you want to do.
That's a lot of what we do is, and I usually tell clients, especially if I see them start to really struggle with the emotional side of what they're going through, I tell them, that part of what you're paying me for is to be your objective side. Whoever's going through it is subjective about it because it's happening to them. They're in the middle of the forest, so they can't see the forest for the trees. So they need this person that they've hired to help kind of guide them through that and be on the outside looking in to give them advice. So we can kind of be the objective side. So, and that is part of what we're supposed to do. And in the ethics, the ethics rules for most states, the attorney ethics say, part of what you're supposed to do, and that's where we're sometimes called counselors. That is a little part. Now, we're not giving psychological advice, but part of what we're supposed to do is try to guide the client through that process.
Right.
And I want to talk about something else on communication. We use a program called Slack in our office, and it's basically a program that kind of creates chat rooms. Is the best way I know how to describe it. And they're called channels. We have a channel for every case. So, Eric, if you were one of our clients, we would have an Eric Carroll channel. Right. And anytime we needed to communicate about anything regarding Eric's case, it goes on there. So, and something will pop up on my phone when I go in my Slack and look, oh, something's going on in Eric's case. I can click on that and see it. The reason I bring that up is because it goes to what you were talking about. A lot of times clients don't know all the work we're doing. They may not hear anything for weeks because we're waiting for discovery responses or waiting for a hearing to come or whatever. And I think they feel like that's just like everything else in life. If you don't hear anything, then nothing's going on. And that's not the case. A lot of times we're talking about that case. I'll bring in my associate attorney and say, hey, I've got Eric's case and an issue came up I need to ask you about. We're constantly looking at those cases regularly. And yeah, there's a lot of work that goes on that your attorney's doing that you don't know about. And, we just don't call you up and say, hey, let me tell you what I did today.
Right. So guys, if you need to get in touch with your attorney, tell him to cut you some slack.
That's right. But again,
I couldn't help myself. I'm sorry.
But again, and we deal with the same thing. We have clients that drop off the face of the earth, and we're trying to get a hearing set, can't find them. I mean, it happens. But again, make an appointment, go sit down in front of your attorney and get on the same page.
There you go. Anthony Conti said, if you have an attorney extorting you for money under the color of law for their client, engaged in criminal misconduct knowingly and still wants to pursue action, what can you do? No show calls so far. Well,
if all of that is accurate, I mean, that's all illegal. You may need to go talk to a prosecutor about it. I mean, that's pretty serious stuff. Is not supposed to be going on. I think you need to go talk to somebody, or at least go talk to another attorney, another criminal, maybe a criminal attorney or someone like that, and tell them what's going on and get their advice on it. But you may need to go to the prosecutor.
Got it. Shannon Hall, your comment cut off. If you can put that in a couple of parts or condense it down, I will bring it to Kevin. Erica Elvina Brown said, I'm in California and the mother of my grandson told two judges on Friday that she had legal counsel and named the lawyer. I personally called him and he said he isn't representing her and has not had any contact with her. What will the judges do about her lying under oath to them?
Erica, I don't know if a whole lot will be done about that. It will certainly hurt her credibility. I will tell you sometimes, and I'm not saying this happened in your situation, but sometimes a a person will come meet with me, and I will quote them our retainer or whatever, and they say they're going to get back with us and hire us, and sometimes we never hear from them again. And sometimes they will go to court the next day and say, Kevin Hickey's my attorney, and blah, blah, blah. And then the court never hears from us, and I get a call weeks later, I thought you were this person's attorney. And it's like, no, they never hire. I mean, all kinds of things can happen when a person's deciding whether they're hiring you, not hiring you, whether they can afford the retainer or not. So it becomes kind of a gray area there for a while. So I don't know what happened here. If she directly lied about it, I guess it could be brought up at a later hearing to reflect on her credibility.
Got it. Hakuna Matata. I like the name. Said, hey, at Dad Talk, what should be dealt first, custody or divorce? If custody is second, is it not tougher to get a positive result? And shouldn't children be first port of call?
I'm thinking he's saying he's got either a custody case or a divorce case. Usually that's all handled. If you're married and filing for divorce, usually all of that is handled at the final hearing. Custody, property issues, all of it. So I don't know if you're really dealing with it first, but it's usually handled all at the same time.
Yep. Eric Ritt Smith said, does res judicata apply to both criminal and civil cases both? How do I make sure the other party is not allowed to speak on previous issues because she is the type I am afraid will try to get the judge to overturn the order for March 16th last week? Hearing is Thursday at 1:30 p.m. Central Time.
Well, to answer the first question, yes, it applies to criminal and civil cases. A lot of times in criminal cases, though, it never comes up again because you have like a double jeopardy kind of issue. It just depends. But the thing I do is, like I said earlier, I object. If someone starts trying to bring something up that I think's already been covered and decided, I just object to it and bring it to the judge's attention. I'm not sure you just had a case last week. And it sounds like you got another hearing coming up, or had a hearing last week and you got another one this week. I'm not sure about that. So I don't know if your particular situation is going to fall into a res judicata situation that fast or not. I just have to know more about it.
Got it. Dave Murray said, what do you do when CPS commits fraud in medical records and you catch them?
Not really sure on that. If they falsified medical records or something like that, that absolutely needs to be brought up in court. Many times CPS could actually be sued for that. That's outside the scope of their policies, their normal policies. It just needs to be brought up in court, brought to the attention of the judge that there's a major problem with the records, and that CPS is the one that did it. I don't think a judge is going to be very happy about that.
Got it. Roger Tolbert said, my child's mother was involved in a felony domestic violence as a victim, and the suspect is still around. What's the chances of the judge giving me my son full time?
I think it would depend on what around means. If this was, I'm guessing, yeah, this is the suspect. Okay. If she's still having him around, that could be a real problem. You've got to let the court know about that, and let the court know that mom's not making a very good decision as far as who she's having around the children, having around the child, and that maybe custody needs to be changed. I think that's how you handle that.
I appreciate it, Roger. Roger's got a new barbecue sauce, Kevin, that they gave to us. It's called Baby's Daddy Barbecue Sauce because he's worth keeping around.
There you go. I need to get some of that.
Oh, man, it's good. It really is good.
I'm a big home cook. I cook all the time. So,
yeah, hopefully he'll have it out sometime soon. I told him we'll definitely plug it on the show. So, all right, Roger, I hope you get something going with that. So I found Shannon's question. I might not be able to pull it up on the screen, and it's a little long, so I'm going to read this to you real quick, Kevin. She said, grandmother repeatedly called DSS and 911 until DSS had mom sign plan and send son to then until court. Joint custody to parents and PT I guess, part-time to grands. Visits at their discretion. Grands never have acknowledged much of the joint right to mom or family. Dad died 9/20. Corona alienation is almost up, so who knows what is the plan to push mom away. If mom has been sent abusive recording, audio, or abusive event towards son, fear of foster care scares out of calling DSS. Should mom go to courts or attorney with recording? He could end up further away. Already alienation and fear worse abuse if in DSS system. Grandmother deserves the DSS crap she sent to mom and child to take him. So the question was again, should mom go to courts or attorney with recording?
Yeah, there's a lot of stuff there. I'd probably go to an attorney and go over that first before you just went straight to court with it.
Yep. Always best to talk to him, guys. John Rybolt said, how do you make a person obey a judge's order that interprets how she wants it when it benefits her? We've been to court 5 times. I'm military, and the only resolve I have is to hire an attorney to make sure I get to see our child. Nothing is wrong with the order, but she doesn't follow it.
Yes, and I know no one likes that answer, but yes, you need to hire an attorney and you need to go back to court. I talked earlier about numbering motions for contempt, first, second, third, fourth, to try to get across to a judge how many times we've been to court before. And let's talk about contempt for a minute. And when a party's not following a court order, unless it's pretty egregious at the first time you go to court over contempt, a judge is normally, it just depends on the case, but a lot of times they're just going to caution that parent and say, look, you need to stop acting this way. Don't violate the court orders anymore. Sometimes they may order a little bit of attorney's fees, or sometimes they may put some other kind of punishment there. But the first time, they usually want to give them an opportunity. But if it starts happening over and over, a judge has contempt powers to do all kinds of things, all the way up to putting the person in jail. They can fine them thousands of dollars. They can make them pay the other side's attorney's fees. So when I've had to start going back to court, and like John's talking about here, he's been back 5 times. If those are all over contempt, all those times you had to go to court, I'm making the judge understand that. And I'm going to say something like, Judge, we've been here 4 times before. This court has really given this mother an opportunity to comply with this court's orders, and she just does not. It's not getting through to her. Something significant and severe needs to be done to her to get the point across. And then we usually ask for attorney's fees. If it's serious enough, we ask for some kind of jail time. Contempt over and over can be grounds for changing custody. Just remember, a judge has a wide range of things that they can do to a person to try to get them to comply with an order, and you may just have to really, really enforce that to the judge.
Got it. Dave Murray says, what do you do when a judge lets the opposing attorney view CPS records but denied your attorney to review in-chamber records?
That's a problem. Yeah, I'd have to know. I'd have a problem with that. If that happened to me in court and the other attorney was seeing some records, I can't imagine a judge not letting me see them too. I will tell you, in CPS cases, a lot of times it's DHS in Arkansas will get away with, when it comes to foster parents, they can sometimes know who the foster parents are and not necessarily let us know who they are, because sometimes I want to do discovery and want to know how the child's doing in the foster home, and they won't give us certain information on that. Other than that, both attorneys are usually entitled to see any records.
Yeah. Ted Mooningham said, guardian ad litem appointed asked judge emergency removal. Ex-wife tried to get guardian ad litem removed and denied 3 times. Then ex-wife hired a guardian ad litem attorney to represent my son without consent or knowledge, with a fully enforced parenting plan in place with custody. Motion to remove, ?
Yeah, I assume he means a motion to remove the one that his ex-wife hired, and I would say absolutely that's what you would do. The court appoints attorneys in most of the states I know about, and they appoint them for a reason. And this court wanted the original GAL, the original ad litem on that case. And I guess the ex-wife can hire whoever she wants, but they're not going to be able to represent that child unless the court orders it.
There you go. David Caston said, if my child's mother and I had our child taken for a short period by CPS and I am not on the birth certificate and the charge wasn't against me, but I had to participate with court orders to get our child back, does that make me a legal guardian or named parent father?
Not necessarily. And that's a really good question. You can be on a birth certificate as the father and not be the legal father. You still may need to file a paternity action. A lot of times, if you had a CPS case, a juvenile court case opened, a lot of times as part of that, they will do a paternity proceeding to legally name you the father. If that case is still going on, you probably need to take advantage of that fact that you have got a case open and try to get paternity established. So no, it does not necessarily make you a legal guardian. Normally in those juvenile cases, that's what happens, but you want to make sure that's what happens. So be sure and have your attorney make sure you're named the legal father.
All right. Thank you for that, David. We're getting near the end, guys. Merger Music and Film said, Dad Talk Today. Kevin, if someone just can't afford representation, what's your best advice for someone representing themselves, assuming they are competent and a good parent? Fool for a lawyer.
Well, and I know that old saying, the person that represents himself has a fool for a lawyer. It's hard, and I've actually spoken with Eric a little bit about this. We may be providing some kind of services in the future for people that just cannot afford an attorney and are forced to go to court and just don't have any other option, to consult with them about some basic rules of what they're going to, decorum in the court and how to present some evidence and question a witness. Because sometimes you just can't afford an attorney. It's never advised. And that's the first thing I would tell anyone that would call me to consult about that is, if there's any way possible, family, whatever, to get an attorney, you need to get one, because the other side's probably going to have one, and you're really going to be at a disadvantage. But that's as good of advice as I can give you.
All right. Anthony said, no DA or official due to the relationship with this person want to prosecute them. Fired prior counsel for violating statutory duty. 2 years, no show cause of infamous crimes they allege. No actions taken against me other than hiring a guardian ad litem and mediation today, where they just wanted money. I wanted for our child to enjoy his parents equally. No budge. They broke the law prior to the petition and continue to be in violation to this day since 2019. I thought there was a question in there, but I think he was just following up with what he was saying up above. And Adam, you had a question in here, my man, but it got cut off. I'm going to get to Michael's question, guys. We're going to have to cut it here. We're right at an hour, and I promise you, Kevin will be back in 2 weeks. Melissa and Rhett will be here next Monday. So if you guys get in here, get your questions in, we'll make sure to get them asked. Michael Gilligan said, what force in law does an administrative income withholding order unsigned by a judicial officer when delivered to an employer or payer, like a pension fund with general counsel, have? Is it just a cooperative agreement with the child support enforcement unit and the employer or payer?
I think I know what he's talking about. We have a notice, and I haven't sent one out in a long time, because most in the orders I do, I tell the payor parent, we usually put it in bold, it's your responsibility to take this order to your employer, make sure you get child support set up and the withholding set up. But sometimes we send what we call a notice of child support order, or notice of wage withholding. So we would send it to the paying parent's employer and say, you need to be aware this parent is supposed to be paying X amount per month. Start taking that out of their payroll. I think what he's talking about when he says an administrative income withholding order that's not signed probably by a judge is probably what they're talking about, because when I've sent those out before, they're just signed by me. They're not signed by a judge. But I've always looked at that as just a notification of the main order that was signed by the judge saying what was supposed to be withdrawn. So as far as cooperative agreement, Michael, I don't know if that's probably not really the words I would use, but I'm betting that's what was sent to the employer was, hey, this order's been entered. Here's what so-and-so is supposed to be paying, and this is what you need to be deducting out of his check. That's probably what that is.
Gotcha. I said last question. This is real quick. I know we're trying to build something up for this guy, so hang with us because this is probably a number one question we get asked is if we know any attorneys. I'll ask you though, Kevin. Shannon said any Central Virginia attorney referral contacts.
So, Shannon, I'm sorry, I don't have any in Central Virginia. I don't know what kind of case you have. We take cases all over the country that involve parental alienation and abuse, false abuse allegations, high conflict custody cases. We are hired on all those cases across the country. We get admitted through a process called Pro Hoc Vice, and we associate with local counsel and work on cases. So I'd certainly be happy to talk to you about that, but I don't know anyone in Central Virginia.
All right. Well, Kevin, I sure do appreciate you coming on here, man. I'm liking this. I see you got a little bit of a tan going on from the vacation. Everybody needs to get a little break from this every once in a while, man. But tell everybody where they can keep up with you and where they can reach out to you if they want to get your services.
You can go to our website, which is kevinhickeylaw.com. That's all one word. You can call us at our office, 479-434-2414. We are in Fort Smith, Arkansas is where my main office is. But like I said a minute ago, the high conflict custody cases, parental alienation cases, and false abuse allegation cases, which seems to be coming up more and more, and it is becoming, unfortunately, more and more common in custody cases. We take those kinds of cases all over the country and can certainly consult with you about that.
All right. Well, everybody join Kevin again in 2 weeks. Next week, we will be live with Melissa Isaac and Rhett Clock, and we will see you then. Kevin, I appreciate it, my man.
Thanks, man. Everybody take care.
Thank you for joining us tonight. We are fighting for the rights of parents worldwide. If you want to help support our podcast and for us to continue this mission, please join us at patreon.com/DadTalkToday. You will find us on Facebook, YouTube, Instagram, Twitter, CloutHub, Parler, iHeartRadio, Stitcher, Spotify, the podcast app, Google, Apple Podcasts. We're a little bit of everywhere. And guys, every time you like and subscribe, you help us continue this mission. Thank you, and we will see you next time.